11th. Just all stand, please, for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Now, Tammy, would you swear everyone in, please?
Yes. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And if you plan to speak, if you're out there and you plan to speak today, you must be sworn in as well. So if you weren't sworn in, let us know before you do speak, please. Moving on to adoption of last meeting's minutes. Any changes to be made? Board?
Move to adopt as presented.
Second.
Motion carries. Thank you. For the staff, any additions or deletions?
I have several deletions.
Okay, I don't have a complaint.
Case number H, I, and J, all three for Joe Greco, Program Director of I-9 Sports. He's complied and paid his citation. And case number K, which is First Choice Healthcare, Dr. Neil R. Barbinell. I didn't receive service on that, so I pulled the case.
He's in the back.
He's ready.
Somebody raised his hand.
I was getting ready to say, he is, however, here
Okay.
and would like to be heard, and I understand it's up to you, Mr. Chairman.
We'll get to it, but sure, yeah, we'll invite you up. So, Officer Ramsey, clarify that for me, please. We're not going to hear the case, but we're going to hear.
Correct. We're not going to hear the case, but we're going to hear.
We're going to hear.
He would like to be heard.
Testimony of some sort?
Well, that would be testimony outside of the code enforcement hearing, so.
That's right.
Would you prefer, he did not get a notice, but he is here at the hearing, would you prefer, and is it proper for him to move forward and go ahead and have the case? You need to come up and speak to the mic, sir.
I want to understand what you want to speak about and see if it has to do, this is. And we do, by the way, we're going to do this in order, but I need to understand why you're here.
Thank you very much for letting me speak.
Can I get your name, please?
Yeah,
the microphone.
State your
I don't
name and address.
Right.
I have some issues
Can we
with
get your
code
name,
enforcement.
please, sir?
My name is Neil Robert of Barbinell, and I have some issues with code enforcement in the community. Not with code enforcement per se. I think they've done a very fine and professional job, but issues involving the whole situation that make me even be here today, that I was even served with this to begin with. I wanted to make the code enforcement board aware of it and let them know kind of what's going on so that you know the hardships that I've been facing
So
in my place.
you're appealing your case. Is that what I gather?
Yeah, I am appealing it.
Okay.
I mean, I know that it's already been waived, but the very fact that I'm here today, I think the Code Enforcement Board needs to know what's going on and why I'm even here in the first place.
Okay. So the case has been.
It's not been waived. It's been delayed.
It's been delayed.
Because of improper process.
What's the nature of the case? What are we talking about?
Overgrowth in a vehicle with expired registration. Inoperable vehicle.
And the lawn cutting.
Right. See, this is a little unorthodox. Usually, we let people come up and speak to appeal their case, and which is fine. I mean, I welcome that, but I don't know that you just have a general statement, kind of like public comment. Is that what you're trying to do?
Correct.
How long is that going to take?
Not long at all.
Let's hear it out. Sure. Let's go ahead.
Okay. I purchased essentially a bank-owned, vacant, abandoned property about a year and a half ago.
Wait, before we go down this road, I haven't done my part of the agenda where I'm removing something. Can we kind of stay a little bit on task?
Yeah, you're right, Officer Sanderson. We really should. Could I just put you on hold for just one moment, please? Thank you.
Regarding the agenda, case 15 CE 5805, John Zudans and Tracy Lockwood is being pulled from the agenda today due to obtaining necessary approval.
Which one was that?
15 CE 5805.
What number is that?
E, Zudans and Lockwood.
E.
Gotcha.
Okay, yeah, if they go by it.
An elephant. Got it.
Thank you, Chair. Mr. Chair.
You're welcome. Is that all from staff?
May I ask the attorney a question?
Sure.
Mm-hmm.
Are we going to hear this case sometime in the future?
The case that the gentleman is at
Yes.
the podium for?
Yes.
That's what I think I was discussing with the chair. If we're going to actually move forward with this case now, that's one thing. If you're just going to take a brief comment, You don't want it to impinge upon the testimony that might be given the next time the case is actually heard.
That's right. I'm willing to hear. Wait, let me do this before we do. Let's adopt the agenda. Okay.
Move to adopt as ended.
Second. All in favor? Aye. All opposed? Hearing none, motion carries. Thank you. Now, going back to Mr. Barbanel.
Barbanel, correct.
Okay. Legal counsel is indicating that you could be infringing on something that needs to be heard when your case is brought before us, and I'm not sure it's going to be in your best interest.
I'm not worried.
You're not worried? Okay.
No.
Well, if we can keep it brief, then I'm
Very brief.
Yes, sir? Nope.
There we go. We've had people come forward in the past wanting to speak before the board, make comments in general, and we've never allowed it.
We have never allowed it while I've been here.
And not when I've been here either. So let's not set a precedent, I guess. I think it's in the best interest of the board and your best interest if we just let you have a seat and table your comments until your case comes up before us, which I understand if it comes up before us.
It would be more appropriate for him if he has a complaint to go to the city council, where they have an open forum where you can do this.
That's right.
I agree.
That's right.
You need to reserve your testimony when your case is actually before this board, and it's been pulled by the code enforcement officer.
Okay.
Okay. I'm sorry, but yeah,
Thank you for this opportunity.
They've made some good points, but thank you.
Thank you. Thank you very much.
Okay. Moving on, unlicensed contractor citations, case number 15-CE-6056, violator Sam Butler, DBA Butler Builders.
Good afternoon.
Afternoon. Were you sworn in, sir?
No, I wasn't.
Okay. Tammy, would you swear him in, please?
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name for the record, please.
Samuel Butler.
Thank you. Staff, if you would present the case, please.
This isn't a case presentation. I thought this was a board order.
It's not under my...
We did not receive an appeal from Mr. Butler.
It's not under my board order list. So this is actually out of place then. Okay.
Yeah, the 10-day period to pay and the 10-day period to appeal the fine has long since passed. We never heard anything after our initial meeting with Mr. Butler in our office.
Okay.
And we assumed it was going for board order. That's what I thought I was here for today.
Okay. Well, I mean, if that's the case, Mr. Butler, I'm sorry, but that's an admission of guilt when you miss that period of time allotted. So this is actually going to be, this is a case that's brought before the board to issue a board order.
Okay.
And in that case, it doesn't actually give you the opportunity to speak, unfortunately.
Okay.
The opportunity was missed.
Okay. Yeah, I just got the notice to show up to this meeting a couple days ago. I had some change of addresses, so I just need to take care of the citation, basically.
Well, we're going to go through our process here, and we're going to probably, what's going to happen is we're going to issue a board order, and then you can continue with what you need to do with the city. Okay.
Okay.
So you can have a seat, you can leave. We're going to carry on with the case as it's presented to us here. So
okay. So
with the board order.
Oh,
so.
May I ask him a question?
Yes.
Are you aware what the amount of the fine would be?
Yeah, it's a $500 fine for demolition.
As long as you're aware of it, I'm happy.
Yeah, and it seems fair. There's just some other circumstances, and I just wanted to clarify some stuff.
You understand that failure to apply for a hearing or anything is acquiescence to the guilt?
Yeah, I just was made aware of that. Is there anybody I can talk to outside of this meeting, or do I just need to pay the fine? And
if Mr. Chairman,
yes, sir.
If the board has no other reason for me to be here, I'll go after this Mr. Butler's finished and meet him out in the hall, and we can discuss what needs to be done.
It's fine. If this is the only reason you're here, that's fine. Sure. We don't need you here.
Need to be here for? Okay.
Are you seeking a board order still, Mr. Kechi, or?
Yes, we're still seeking a board order.
Well, should we go ahead and proceed with that?
Unless if the board feels or
we can get through that.
Feel that to postpone this for another month, that's
let's go.
I think we have to go.
Yeah, no.
Typically,
we need
we
to
just uphold the citation and we don't issue an order in this.
That's right.
The same as.
We just
Yeah.
make a motion for a board order, which is,
I'll make that motion.
okay, I'll second that motion. All in favor?
Aye.
All opposed? Hearing none, motion carries.
Thank
Okay,
you, David.
thank you. Now you can, sure.
Thank you.
Thank you.
Yes, sir, thank you.
Appreciate it.
Okay, moving on to noncompliance. Request board order case number 15-CE-5708, Francis Jenkins, Tropical Auto Brokers.
This case came before the board in August and was found in violation. The property is now in compliance, so requesting that the board find the property in compliance, assess enforcement cost against the tenant, but waive any continuing penalties due to the testimony of Ms. Jenkins at the August hearing expressing hardship in care of her parents.
Let's see,
May-
wrong page.
What was the nature of the hardship? I don't recall.
I don't either.
Their parents.
In the letter, she states that she's the caregiver for both her mother and her father, and that there seems to be some cognitive issues and physical issues. And as the caregiver, she was unable to take care of things at the business due to taking care of family matters.
Okay, thank you.
Right. And we said that, at that time, we said, look, just make a few changes. I mean, we kind of gave some instruction on what changes needed to be made, and they were
Ms.
made.
Jenkins' son, Todd Jenkins, actually met with myself and my commander, and we are all on the same page, and the property is in compliance.
Okay, so you're just looking for enforcement costs?
Yes, sir. Against the tenant, please, not against the owner.
Okay. $54.35?
Yes, sir.
$54.35. Okay. Well, I find that this property is in compliance and that we issue a board order for payment of enforcement cost of $54.35. For the tenant.
Against the tenant.
Against the tenant. Thank you.
I will make that motion.
I'll have a
Second.
You made it?
seconded.
You made it? Yeah, I'll second.
Second. Okay. All in favor?
Aye.
And all opposed? Hearing none, motion carries. Thank you. Next case, number 15-CE-5681. This is violator is Irene Snyder.
Yep.
Members of the board, good afternoon. I'm going to wait a second for
Sure.
Sanderson.
Sure.
But as y'all are aware, this is solely a compliance hearing. This has previously been before the board.
Mhm.
And I will just elicit brief testimony
Sure.
from Ms. Sanderson. And for the record, Nick Zabresny from Frost Vandenboom.
Thank you.
That's a great name. What is that? Zabreski is, what is that, Polish?
Polish, yeah.
Yeah.
Thank
Great.
you.
Sorry.
That's one of the things I love
It's
about
okay.
about being on a board or on the city council. There's so many people with so many varied names that come up here. There's just a great melting pot of America.
Mm-hmm. That's right. I agree. Officer Sanderson, did you want to brief us on this case? I'm sorry, you ready?
I'm ready. It's just a recall to see if the property is in compliance based on the August hearing.
And Ms. Sanderson, you were the code enforcement officer assigned to this case?
Yes, sir.
From the beginning? Okay. Have you, since the hearing, have you received any documentation or any verification demonstrating to you that this property is in compliance?
No, sir.
Okay. And then I just have brief argument. I don't know if you would like me to wait until I know Mr. Siegel's here today on behalf of Ms. Snyder, but I can certainly go ahead and make my argument.
I think it's probably more appropriate if we wait on that, if you don't mind.
Absolutely.
Yeah. Sorry, I'm trying to turn this off. Okay. So, anyway, we're going to hear from you. Were you waiting on your client, or?
No. She unfortunately has got to work. Couldn't get out of work today, so I can pretty much speak for what's going on here.
Okay.
On my client's
Sure.
behalf.
Whenever you're ready.
Yes, Barry. Thank you very much. Barry Siegel on behalf of Iron Snyder. My office is at 3096 Cardinal Drive. Briefly, this was a citation with a boarding house issue. My client has rented out this home for over 20 years. Recently, the Code Enforcement Board had cited her for issues regarding boarding houses, especially after the change to the boarding house code. If you recall last time that I was here with Ms. Snyder on her behalf, there was an issue that she had leases in place for the various rooms in the home.
Mm-hmm.
And since that time, she's gone back to her tenants and said, we can't do that. You can only rent the entire house. And so since that time, she has entered into leases with her tenants. She has a lease with each tenant for the entire non-exclusive use of the home. And bear in mind, your code provision defines a boarding house as a dwelling unit within which more than one individual room or one suite, but less than the entire dwelling unit is used, maintained, or offered for rental. And so she has now entered into the leases for the entire home with her tenants. I have a blank copy that we can put into the record of the lease. We did not want to put the individual names and contact information of the various tenants in there, but this lease is prepared by me. I can tell you, and I've been sworn, that all the leases with regard to these boilerplate terms are identical, and they are for the rental of the entire home. I know what Nick's argument is. But I don't want to step on his toes or put words in his mouth. And so I think that those are the underlying facts that are here. And with all due respect and professional courtesy to him, I'll let him make his argument, and then probably the best thing to do is a rebuttal. That's fine. It's your committee, but I think that might be the most effective way to move forward.
While I still have your attention, could you clarify for me how that lease looks? Is it 4 people with a lease for the whole home at this point, or is it 4 people on one lease for the whole home? Does that make sense?
There are 4 there's 3. Right now in this home, there are 3 tenants in the home.
Okay.
And so there's 3 leases, 1 person per lease for 3 leases within the home. But again, the leases are all for the entire home and for the non-exclusive use of the home.
Question.
Sure.
At the optimum, how many tenants could occupy that home?
I believe it's a 4-bedroom home, so 4 tenants.
Thank you.
That's what you said last meeting. So, if I'm being put on this, would you repeat your last name again, Nick? Zabresny.
Correct.
Okay, Mr. Zabresny, if you want to come up and
Mr. Chairman,
speak.
if I can just provide this copy, please.
Sure.
Good afternoon again.
Afternoon.
I understand the intent behind having a lease, but again, as Mr. Siegel stated, these are 4 separate leases. And going back to the beginning, that was the issue. As you recall, there was a lease burning party that was discussed at the hearing last time. Referencing Chapter 60, the definition of boarding house, it does state it is a dwelling unit within which more than one individual room or suite, but less than the entire dwelling unit is used, maintained, or offered for rent. So less than the entire dwelling unit is offered for rent. Inherent in that is the idea that the entire dwelling unit has to be rented for it not to be a boarding house. Well, you can't have that if you have 3 separate leases with 3 different individuals, each of these individuals not having responsibility for the other individual's rooms. So that's kind of the underlying issue here. And if I will reference the board, and I will actually give the clerk a copy of Mr. McGeary's letter to Mr. Siegel in reference to this case, dated June 22nd, 2015. And on the top of the second page, it says she had been told, referencing Ms. Snyder, because the paragraph does begin Ms. Snyder, by the planning director that she could easily resolve this problem by entering into one lease agreement with 1 or more individuals for the entire single-family residence, rather than entering into separate leases with each individual for a specific bedroom suite with access to common living, kitchen, and laundry facilities. She ignored this advice. And she continues to ignore this advice. This could easily be remedied by entering into one lease with all of the tenants. So with that being said, and with obviously Mr. McGeary's interpretation and the fact that by entering into 3 separate leases, it's still being operated as a boarding house and is not in compliance.
What are the length of the leases?
I have not actually seen that. I just was provided this today, and I don't know that this necessarily even has that information in it. So I received this when you received this. As you heard from Ms. Sanderson, she had not received a copy of any of the leases to date either.
I think Mr. Siegel is going to present that to us today, right? Are you gonna, yeah.
I think we're really splitting hairs here, aren't we?
Right,
If there's
really are.
one
greenhouse.
lease per person, it's a non-exclusive lease for the use of the whole house, as opposed to one lease with 3 lessees.
Unless you assume they're all using their bedrooms.
Well,
I mean, I know that's
you're using the couch or the chair you're sitting on right now too, but
right.
And I understand, and I certainly understand it, but clear language and what the definition of
yeah,
a
but every
building
time
house.
you spoke about the language, you said one room or one suite of rooms with common areas, and it seems, I haven't read the lease yet either, but it seems like the lease is a non-exclusive lease for the use of the whole house, which would mean, in theory, that you might
be
face
able
some
to
other
use
consequences, but you could go in the other guy's room and sleep in his bed or whatever.
Right. I mean, this might have been a very clever way to loophole.
Well,
and if it is, then it is. But let's, Mr. Siegel, I'm sure you have some sort of rebuttal. So if you want to present that.
No, absolutely.
If I can't just address the issue of the lease, I mean, long is somewhat of a subjective term to attorneys. This is nothing. Some people may think this is a long lease, but what this is actually commonly referred to as the FAR-BAR lease. But realistically, what this is the residential lease approved by the Florida Supreme Court. And so you'll typically see this in about 99% of the rentals where you have someone that doesn't otherwise go to Office Depot or one of the forum stores and gets their own lease. This is the Florida Supreme Court lease that's there. But it feels like an A. So if the length means something, but I think Mr. Noonan is dead on with it. There's no difference between one lease with 3 names on it or 3 leases with 1 name on it. They're non-exclusive leases, and so that means when these people sign this lease, they go into that home with the same rights and the same issues that come with they all signed on the same lease. They have to work out who's going to sleep where, who's going to keep what in the refrigerator. Just as the example we've always gone back to is when you have 3 flight safety students that want to rent a house together and they sign a lease, they still have to go through and do the same things. And that's exactly what you have here. And you only have the code before you to enforce. You're the code enforcement board, and you can only enforce the code. And the code that is before you to enforce today requires to find a boarding house that there's been some kind of rental of something less than the entire home, period. And that's not what you have here. The leases are for the non-exclusive rental of the entire home. And there's no evidence otherwise that would provide that you've got a situation here that meets the definition of a boarding house.
And again, the length of the leases are the same for each person?
Oh, yeah. Everybody's got the same lease, they just change out names.
Which is for
how long is the term of the lease?
A year?
The term of the lease.
The term of them. She did them, I believe, for annual leases.
Is it not stated within the lease?
Well, what I've got here is the boilerplate language in there.
Oh, I thought you had a copy of
the start and a finish.
Right. But the term, how long it's for is irrelevant. It's whether or not the lease is for 1 person or 3 people. That's the whole point.
And it has to be over 30 days.
Well, over 30 days is a whole different set of problems, of course. Anything under 6 months is a tax issue, but again, not a code enforcement matter. But for you, the only thing that you're looking for is this a lease of a room? And that's actually the problem. If you look at Mr. McGarry's letter from last time, Mr. McGarry was saying that you can't have leases that designate a bedroom. And these people do not have that in their leases. And going back historically, she's never had that until she had a meeting with Mr. McGarry, and I'm convinced, just misunderstood what Mr. McGarry said, and that's what led to her coming back with leases for these people, period, let alone leases that had designated rooms. And so the city, last time we were here, there was great interest that she have written leases, and so she now has written leases for the non-exclusive possession of the entire home.
Question.
Yes, sir.
You brought up the word taxed. What is the situation tax-wise with the state? Is she registered with the state, or is she not registered with the state?
Well, she does not have to collect sales tax on residential rentals. The only time that you would have the sales tax would be if there's rentals for 6 months or less. And so she's always traditionally had a minimum 1 year.
And can you describe the property, namely the driveway? Parking for how many cars?
To be honest with you, I think Melody probably would know it better than I would. She's been there, but I believe 4 cars have always fit in there more than comfortably.
I think it's like a 2-car driveway, and they can park 4 deep as long as they didn't block the sidewalk.
Okay.
Right. Yeah. I don't think I've ever really.
And the house has a single entrance?
It's a regular home, right?
Well, I don't know that because we're not allowed to know.
Yes, it's a standard single-family residence.
Let me say something, Mr. Siegel. I'm not for this type of rental, but it doesn't matter what I'm for. I think that this is my personal opinion and statement, I think you've been very clever in what you've done, and I think you're following the letter of the law, of the regulation. So I just want to put that out there.
I don't know if that's a compliment.
It's kind of a compliment.
Okay. This is something that she's been doing for over 2 decades. These leases are only here realistically because that is the indication that the board has wanted. She's been doing this for longer than many people have been living here in Vero Beach and without any real problems.
It's like 20 years, something like that.
It's at least been 20 years that she does it.
Me too, but I know the point. Mr. Zabrisny, sorry.
You're good. Just brief rebuttal and more or less just addressing a point brought up by Mr. Siegel and Mr. Noonan. I understand it's your position that we could be splitting hairs, but something Mr. Siegel stated is you are the code enforcement board, you enforce the code. But Section 2303 says, and subsection Q, the findings and determination of the board shall be based on a preponderance of the evidence presented at the hearing and the interpretation and application of the code provisions as set forth by the designated administrative authority, who's Mr. McGeary, the planning director. Well, we have his interpretation and application in this letter, which specifically states that 1 lease with these individuals is required, not multiple leases. So based on that, it's improper to have multiple leases, especially since that was, it's not just this ad hoc principle that's, we're bringing up now. This is something that Mr. McGeary told Ms. Snyder back in June of this year, and still there has not been a single lease entered into.
And the problem is, if we base this entirely on Mr. McGeary's interpretation, then there's really no reason for us to be here, because he could say at any point in time, I interpret X, Y, or Z. It could be any case brought before us, and this is my interpretation, and we would have to say, okay, So
and the code was changed, so that we have to do that.
Mr. Chairman.
That's right.
And then his interpretation would need to be appealed to the Planning and Zoning Board and then returned back to the Zoning Board.
Well, this wasn't an official, this wasn't a requested interpretation application pursuant to 2303. This wasn't an appeal taken. This was just a requested pursuant to his designated authority under the planning director's authority.
Has Mr. McGeary seen this lease?
I don't know if anyone has seen this lease other than Mr. Siegel. It was just provided today.
Did you get a copy of it as well?
I got one this morning, or right before the hearing began.
Me as well.
Mr. McGeary is pretty much out of the loop on the code enforcement world, where when this started years ago, it all went through Mr. McGary's office, and if this code board cares to listen to anything I say, I would say put him back into it. I thought he was very effective with it. So though Mr. McGeary had not done it, I reached out to Lieutenant Monaco and to Melody to let them know how we'd resolved the problem, but no one had contacted us until I heard from Nick yesterday, and then Lieutenant Monaco contacted me this morning to indicate that he had been reassigned within the police department to do it. But no one had called to say, well, let's see a copy of the lease or something like that.
Mr. Chairman, I would like to speak.
Sure.
With all due respect to Mr. McGarry and his opinion, those members sitting here have an opinion also and an interpretation. I happen to disagree with Mr. McGarry on his interpretation, and I believe I know what the spirit and the intent of the law is at this time and has been for a while, despite the many court cases that have gone on in the past and are probably still being resolved. I believe, in this head of mine, that the spirit and intent was to not have this situation. I think you've done an excellent job of representing your person, but I have to disagree with you, Mr. Siegel, because of my interpretation of things around here. Thank you.
And as a matter of point, as from years and years gone by that I've been in the council and on these and many other, these committees are to see if the codes have been applied appropriately by the city employees. We do have the right to interpret. And we're interpreting Mr. McGarry's rendition of what is supposed to be. So all of us do have the right to interpret the law.
Michelle, did you have something you want to say?
Yes, if this is passed and these leases are enforced, does that not open up a whole bag of worms where everybody can start doing that?
In theory,
they
theory, yes, it would.
That's what they're trying to do.
And I have a question for staff. So, with regard to Mr. McGarry's interpretation and our responsibilities as the law is today, do I understand that we must go by his interpretation? Is that what I'm hearing? Because
can I address Mr. McGarry's? I have a rebuttal to his rebuttal.
Sure.
Mr. McGarry's letter was Mr. McGarry's letter was addressing leases that it had individual rooms contained on it. Mr. McGarry was saying is you can't have leases designating out individual rooms. And if you look at the letter again, that was the problem that Mr. McGarry was addressing. There is no difference between the separate leases or the collective lease. The problem was you had designated rooms, and that was never her desire and intent to do, and she only did that as a result of a misunderstanding that she had with what Mr. McGarry had told her. But that's what Mr. McGarry's opinion is. You can't designate rooms on the leases, period.
May I speak? If we must follow 100% Mr. McGarry's interpretation, then there is no need for us to sit here.
That's correct. I'm just saying we're here to interpret.
We are here to interpret the rules, the laws, the ordinances with our own intellect. He has his opinion. I have mine. These people have their own. And nobody can dissuade me if I believe what I believe. Thank you.
And members of the board, I just want to make a clarification so that no one feels misled. This letter that Mr. McGarry issued to Mr. Siegel was not a request for an appeal of the code enforcement officer's interpretation and application of the code provision pursuant to 2303, as we've seen in some other cases recently. So this wasn't an official appeal requesting a decision as to the code enforcement officer's interpretation and application. This is Mr. McGarry's letter in response to a letter that Mr. Siegel sent Mr. McGarry regarding this matter. And I know that sounds convoluted, but I want to make sure that everyone just understands where this is coming from. And so I'm not suggesting to the board that this was an official appeal taken by Ms. Snyder pursuant to the code and a decision rendered as to the code enforcement officer's interpretation and application of the code provisions.
Understand.
And we're not taking the position, I know this doesn't help with you, but we're not taking the position that Mr. McGarry has issued some kind of binding interpretation like we've seen in other cases. That I don't think that's the case here. I mean, we do think that we agree that with regard to individual room rentals that there's an issue there. But if I can just reserve just a minute for closing argument after Mr. Zabriskie would be
getting closer.
Yeah.
I'm not going to belabor and beat a dead horse, but I will say that it's very clear what Mr. McGarry's interpretation is as to what is required. And in fact, Ms. Snyder had notice of this in June and was told that she needed to enter into a lease, one lease with all of these individuals, as opposed to separate leases. Instead of doing that, as we heard in the previous hearing, there was subsequent to that some lease burning party that occurred, and to date she still has not entered into a single lease with these individuals, and by doing so, or by not doing so, is still operating a boarding house. Because each of these individuals are not responsible for the other individuals' rooms.
I disagree, though.
You can insinuate that. There are single leases for the entire house. There's 3 single leases for the entire house. The overlapping leases.
I understand that, but I would certainly submit that is something that is especially considering the code, it's physically impossible to have 3 separate leases for an entire residence.
I understand. I understand that point of view.
Sure.
Mm-hmm. I just think that it's a clever way that Mr. Siegel has come up with, keeping with the letter of the law, and that's my opinion. So we can continue to listen to testimony, or we can put a motion on the floor.
I would like to make a motion.
He has some closing argument.
Oh, I'm sorry.
Sorry, Mr. Siegel.
Just briefly. We've talked about it before, but when I've been before this board, that there is a due process requirement that my client is entitled to, and that part of that is notice of the law and notice of what she is allowed to do, what she is not allowed to do, and that derives from the code provisions, from the very plain reading of the code provisions. The code before you, for you to enforce, says that a boarding house requires the rental of less than the entire home. You have no evidence before you today. At best, you have insinuations. You have no evidence before you today that there is anything happening here other than the rental of the entire house. There is no difference in this situation than if all 3 of those names were on the same lease. That is the same exact effect that you have here. And there's no legal cognizable difference. If you find that she is operating a boarding house, you are taking the code that the city of Vero Beach has adopted, that the city council has adopted, and you are changing it to find other facts and other interpretations of the law. You do not have sufficient facts before you to find that there is anything other than the rental of the entire home.
Which, by the way, it's been found that code's pretty loose and not so ironclad in the past.
It's very difficult to write code provisions.
It is. It is very difficult.
That's why you have interpretations.
But at the same time, we have an obligation to our citizenry that they know what the law is, and they have that the government will follow what that law says.
Okay.
Well, I think the law has been pretty clear, especially with the interpretation Mr. Gary has given us. I make a motion that they are still in violation.
I'll second that motion.
Okay. All in favor?
Aye.
All opposed?
No.
No. 2 to hearing. It's
3 to 2.
It's 3 to 2, right? You said.
Yes.
Aye. Okay. 3 to 2. So motion carries. Thank you, gentlemen. Okay. Case number 15-CE-5770, Justin Russ and Randall Flincham. Yes,
Good afternoon. I actually am here on this case as well, and I want to bring something to the attention of the board. The Filchams have paid the fine in this matter, and as doing so, it's an admission of guilt.
Right.
Therefore, there is no basis for this hearing.
This was
good point.
You're talking about the past case?
No.
This one current.
The case that was just called Mr. Filcham's case, Flincham. I'm sorry.
Okay.
So I wanted to bring that to the board's attention, and clearly by doing so, there was no basis.
Already acquiesced to the guilt.
This was the one that we wanted to know. Mr. Flincham had 2 electric meters on the same property, and we want to know if there was a grandfathering situation.
Yeah.
So I don't know who could. Did we ever figure that out?
I will say that Mr. McGarry did issue an interpretation in this matter regarding this. And,
It's in your backup.
I could get my iPad and find it, I suppose.
I will read the last paragraph, and I will give you all a copy, but it says, therefore, it is my official determination as Planning and Development Director that no basis exists for the vesting or grandfathering of the accessory structure as a dwelling, and that the conversion and use of the accessory structure as a dwelling is in clear violation of the zoning regulations and building code.
So he said there is no grandfathering. That's what I took out of that.
Yep.
That's correct.
Okay, Mr. Flincham, you realize that, and Mr. Zabresny is correct that I know you did it in good faith and everything else. You need to pay the fines, but it's an admission of guilt. Sure.
The first thing, the guilt thing.
Can we get your name, please?
Yeah, state your name.
I paid the fine because
Mr. Flincham, state your name for the record, please.
I'm sorry, Randall Flincham, Vero Beach, Florida.
Thank you.
I paid the fine because there was 3 things on there. The other 2 things, my son had some vehicles there that he was working on for some friends, and we got those out of there. That's what we were paying the fine for. I told him, get that stuff off the property. I'll call Melody, get this thing straightened out. I didn't think it was going to be a problem because of the hardship not only hardship, but the violation that I'm getting here is what someone did 60 years ago with the help of the city. The city, the homeowner or the contractor doesn't run the service and sign up for garbage pickup. And I mean, that was done, I'm guessing 60 years ago, or between 50 and 60 years ago.
The house is, what's the year of the house again?
53.
53.
But it's got terrazzo on the floor in there. So my guess was the guy was building a house in a garage, and during the construction, he said, oh, you know what, I'm going to make this a mother-in-law suite. Probably went in the building department, got a revision, just like I used to do 30 years ago. Walk in the back there, Al Bowman would stamp it. I'd walk out and get her done. 60 years ago, I'm sure it was more lax than that. But the city had to okay it. The city inspects and they okay it. You don't just call up and say, hey, I need my electric hooked up.
That's right.
So
that's right.
They did it 60 years ago. Now it's coming back on me. And when I called Melody about it, the complaint was that the property wasn't big enough for 2 units. And I said, well, there's a duplex across the street, same size. I said, I said, so you're going to tell me they're going to tear that down also? She goes, well, if I get a complaint, which I thought that was kind of bizarre. But there's actually 4 of them that I can throw a rock at from my property on the same size property. And what happened 60 years ago, and now all of a sudden they're coming to me and telling me I got to tear this thing down. I think it's ridiculous.
I'm not going to disagree with that.
Question. Could you give me the history of this accessory building?
Well, I bought it 20 years ago, and it was an apartment then. And I called the guy I bought it from, and he said it was an apartment when he bought it, but he didn't know how long it's been. But it has terrazzo on the floor and mud set tile, so it has to be 50s, early 60s. But they've been getting, it says right on the electric bill, a garage apartment. And I doubt, someone doesn't rent out the apartment and call the city and say, you forgot to charge me for their garbage. And someone had to hook that meter up. It's a separate meter. It's not ran over by an extension.
Somebody's been paying electric bills on that unit for years. Somebody's been paying for the garbage pickup for that unit for years. And now all of a sudden it's an issue.
Now I'm the bad guy.
And it's not like you built it last week.
No, and I've lived over there for 13 years. I don't live there now, but I've lived there for 13 years. And I did a lot of renovations over there and made the neighborhood nicer than it was when I came. And even my personal home over there was 3 feet into the setback. That was original town. Things were done a little differently. But coming back now, 60 years later, and saying that, that
it's not grandfathered and it doesn't meet.
I think it's ridiculous.
Right.
And
question.
Code.
Isn't it true? Was this once a garage? And isn't it true if it was a garage, it can have electricity on its own meter?
I'm not aware of that.
Okay.
I don't know anybody that would put a garage and have his own meter because you pay minimum fees. It would be kind of bizarre to do that. But they do have it down at the city as a garage apartment, and you pay for garbage.
And the fact that it's there means that it was at some point in time approved.
Yes, someone had to approve it.
Somebody did. Probably long gone.
Yeah.
Yeah, the codes have had a long metamorphosis from back in the 50s. And these are one of the things that slipped by and has come to us now, come to roost.
Right.
That'd be like going to Ocean Grill and complaining that the bar's hanging over the setback.
Ocean. That's right.
And say, hey, I'd like to find that at the building department.
That's right. That's exactly right.
Well, we've got a bit of a conundrum because
now we've got this interpretation from the planning.
Yeah, and the other conundrum is that we asked to go because he paid the fine.
Yes, and that's very clear in the code.
Could you repeat that a little louder?
That's very clear in the code and on the citation, and I believe the code enforcement officers make that very apparent to the people they are citing.
Yep.
Well, he said he paid the fine to deal with the other 2.
Well, wait a minute. When I came down to pay that fine, I told the girl, I said, well, I got to talk to the lady about this one that I'm paying for because the vehicles were there without a tag. So, if you're going to punish me for some loophole, I think that's kind of ridiculous.
It's not a loophole, but you paid it all in good faith. I think you had like three citations there, and you're like, okay, pay them, get them out of here. Let's get them done.
I've never had a citation before. I didn't know but I knew 2 of them was legit. The kid shouldn't have had the crap sitting out there. So Would it have been $17, or would it be divided by 3? I mean, what would the fine been different?
I have a couple of questions. You put in a curb cut.
Mm-hmm.
Could you tell us what precipitated that action?
Well, because there's no parking. There's no parking on that place. There's 2 in the back, and there's everybody was parking on the street. And to park on the street, you have to park on the other side, and then cars can't get by. So he put a little driveway in there.
Okay, and what is the state of this building at this moment in time?
He's living there.
Yeah. Who's living there?
My son.
Okay.
It's actually going to my ex-wife, I think, next week or 2 weeks.
Did you get the proper permitting from the city?
For the driveway?
No. For the whatever you did on the inside. Did you improve it for your son?
No. He just moved in there. He hasn't done anything.
He hasn't done anything. So he
ripped some screen off the front that the cat renter tore up, but he hasn't even painted it yet.
See, we would have room to interpret if you had not paid the fine and had come in and made this argument now. We would have had room to interpret, but you've already admitted to guilt by paying the fine. So you see where we're caught.
Well,
I wish it was
possible
a month
to pay
ago.
a partial fine, or what should he have done?
Yeah, I mean,
divided by 3 and pay 2/3 of it?
Right. Because it was all in one. It was all in one citation.
Yeah, there's
right?
one citation, there's one fine, but several violations.
Several violations on one citation.
Yeah.
That's another. He couldn't break it up and say, hey, if you get a ticket and you say, oh no, it's for $200, but I only want to pay $100.
See, it's kind of weird that we're even hearing this because he's already admitted to guilt.
But this is
So
my
we shouldn't be hearing this.
This is my second trip here.
Well, let me read this and maybe somebody could clarify. The property owner submitted a code compliance certification application to the Planning and Development Department in January 2015, requesting approval to construct a cut curb for a 20-foot driveway. It was approved. Development order plot plan was provided that clearly shows the subject accessory structure as a garage. Attached is Exhibit B. It says here it was a garage, not an apartment. That's my problem.
I don't have any idea what you're talking about there. It might have been. It might have just. It might. I can tell you where that came from. Is my son just took the blueprint that he got from the building department and drew the driveway on there.
I'm not talking about the driveway. I'm talking about it's listed somewhere as a garage.
May I address that?
Yeah, it's kind of rough plan.
We're caught.
To address that specific question, if you look at the document that I provided, which is Mr. McGarry's letter, it actually has all of the documents and all of the permits and the records going back. So it's not an interpretation, it's showing that this is in fact not grandfathered in and never been permitted. But you will see there is a plot plan that was submitted January 23rd of this year, and that is attached, and you will see it's very clear that it's drawn and labeled as a garage.
Back in the 50s and 60s, these things happened all the time. My family's been in construction for 3 generations here. And back in the 50s, 60s, you built what you wanted to build. Didn't ask any questions. And this we're captured now because it's not grandfathered in.
That garage that's drawn on there is not even in the right spot. I mean, that's not correct, even if it was a garage.
Who made these plans?
I have no idea.
Well, it says garage.
Peggy, what do we do here? We're caught. I mean, we need some guidance. I think he's still in violation. I mean, he paid the fines. We don't have an option of. We can't declare him not guilty. He's already declared himself guilty.
Ms. Sanderson, were all of these citations all of the violations were on one citation?
Correct.
And if he pays that citation, he is admitted to the guilt of all the things that are listed on the citation.
My understanding, yes.
Yes.
So if he didn't pay it, he would have been on the hook for all 3 of the violations. He would have been. We would have fined him more for not paying for the other violations.
But he hadn't paid it. He came into compliance, and so that's noted. When the vehicles, the jet skis were removed, it's noted in the case file that part has complied.
The portion of the citation issued,
right.
Like 2/3. It was a 3-part citation, right? Wasn't it? I believe it was. Let's just, for sake of argument, let's say it was. So he satisfied 2/3 of the citation, came into compliance.
3-part, correct. And he satisfied the unlicensed and inoperable motor vehicles by removing the mail truck, and the jet skis were removed from the required front yard.
So, Peggy, how do we get out of this? I mean, we shouldn't even be hearing this. I don't know how it got on the agenda.
I think that's what Mr. Dabrowski said when he first spoke.
Yeah, which means we can't even take a...
We can't take a vote on something that's already declared guilty.
Yeah, we can't make up the rules as we can't make up the rules as board as we go along.
The only way we can dispose of this is I'll make a motion to table it indefinitely. The issue's already settled.
It's
a settled
Can we do
issue.
that?
How do you table a settled issue?
Well, that's right.
Tabling this piece of paper here.
So we're punishing him for
be
paying the
set for a
citation.
compliance hearing,
Yes.
and Mr. Flincham have an opportunity to apply for a permit or have the individual vacate.
Well, then we just pass by this. He'll have to put it on the agenda somehow for a compliance hearing.
Sure.
Mm-hmm.
And that has nothing to do with us. We can't take any action on this other than to table it.
That's right.
And so what would the issues be of all the grandfathering in? Because I know that neighborhood very well. There's a lot of situations set up like that.
Yeah. We can
Tons of
raise
them.
the
I
whole
have a-
place
I
and
have a
make it into a
house-
parking lot for the community church.
I have a house that has
Yep.
five houses on one lot.
Yep.
And I agree with you, but Mr. Fletcher's also correct. We're in this conundrum.
We're captured.
Because of the admittance of guilt, and which Mr. Flincham didn't. He just wanted to pay his fines. It was
Right.
Nothing. He didn't do anything wrong.
Yeah, they should have told me this last month.
I don't think this board is. I don't think at this point. I don't think we can make a decision on it. And Mr. Fletcher is correct. The only thing we can do is say table it indefinitely, and then somehow it's going to have to end up on probably
a compliance hearing. There'll have to be another hearing.
That's right.
And establish what is something
Can-
that's beyond,
And plus, I mean,
grandfathered in. At what time period?
Can we
can
make
you
a
do
motion that 2 of these 3 violations are in compliance, the third one's no longer or is still not in compliance?
Yeah, I would think that the third
And
one would
just
still
set
be in
no
order to
fine.
find in violation.
Yeah, I'll make a motion that.
Could you repeat that, please? I can't hear
Yeah,
you.
I'm getting ready to.
He'll make the motion.
I'll make a motion that the property, the violation for the boat, jet skis, and trailers in the front yard and the unlicensed vehicle are now in compliance, and that the use issue is not in compliance. The board issue an order for payment of the $50 civil penalty, and that's that.
That's right. And I'll second that motion. All in favor?
Aye.
Aye.
Mr. Fletcher?
No.
No.
Oh, wait a minute. Clarify it again, please. I want to hear it again. We're just getting rid of the one section that has to do with...
No.
2 sections.
Part 1 and 2, he's in compliance. Part 3, he's in violation.
And the fine's been paid.
And Part 3, it says what?
Case is closed.
What is Part 3 of the violation?
Part 3 is the usage of
The use is the garage being used as an
structure.
apartment.
What we're trying to do here is we're trying to say, okay, it's not in compliance, but there needs to be a hearing for compliance. We can't make that decision today. All I can say is that 2 parts of the 3-part citation have come into compliance,
And that he has admitted his guilt in that vicinity.
We've just said it's not in compliance.
That's the point. He's admitted guilt to all 3 issues.
Yeah,
It's too convoluted.
That's why it's not in compliance.
It's too convoluted. He
And
pled
tabling it
guilty.
indefinitely is clean?
He pled guilty to 3. You want to vacate 2 out of 3. Okay. I think go ahead with everything and fix everything down the road if you want to fix it. But to piecemeal it, I don't want to be piecemealed.
Yeah.
I want a total package.
But we have a
and
motion
deal
in a
with it.
second. I think we voted. So.
We had a vote. What
Maybe
was
we
the
don't
vote?
have to-
Ms.
Well, I'm
Fox?
changing my. I changed my vote to
was,
no.
Would you
No.
do a poll?
I'll call
Ms.
the roll on
Let's
this.
do a roll call.
Mr. McMahon?
I voted yes.
Mr. Fletcher?
No.
Mr. Pizzicelli?
No.
Ms. Shell?
Yes.
Mr. Noonan?
Yes.
Mr. Howell?
Yes.
Motion passes.
So the existing state now is there will be something down the road on the garage/apartment issue. Am I correct?
That's right. There needs to be a compliance
Okay.
hearing. Yes, sir.
Good enough. Thank you.
So,
Screaming right along at the speed of dark.
that's right.
That's all
That's
we
right.
gotta do.
Yep. That was interesting. Thank you for coming. Case number 15-CE-5706, Joshua and Gloria Jenkins.
Case number
Dagwoods.
15 CE 5706-0599T. I'm requesting a board order finding correction. They've done everything they had to do, including paying their citation.
Okay.
Because it was heard before the board, we
That's
had to do a board order finding for the correction.
Move to find in compliance.
Second.
All in favor?
Aye.
All opposed? Hearing none, motion carries. Thank you. Case number 15-CE-5950, Chris R. Bowles.
Requesting a board order for 15 CE 5950. The violator, Chris Bowles, was cited for weeds, grass, or undergrowth at a height of more than 12 inches at 2450 Cortez Avenue. Citation service was provided by certified mail. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has not been corrected as of this date, and the civil penalty on the citation has not been paid. Not asking for enforcement costs, just asking for the board to find the property in violation against the tenant.
I'll make a motion that there's a violation, the violation continues, and the board issues an order for payment of the original civil penalty and the continuing penalties.
I'll second that. All in favor?
Aye.
If the board will indulge,
Yes, ma'am.
this is a family matter between Mr. Bowles as the tenant and his sister, and she has power of attorney for the property on behalf of their father and has requested to address the board.
And what was the last part?
Okay.
She wants to speak to the board.
Oh, okay. Well, she's allowed to do
Is he
so.
here?
Oops.
Oh.
Yeah, whoops.
Okay.
Let's wait now.
Sorry, it's getting late.
Yeah. It's okay. Were you sworn in, ma'am?
Yes, for
Okay. State your name for the record, please.
Lisa Young. My dad, Roy Bowles, has Alzheimer's disease.
I'm sorry to hear that.
And yes, it's been a very trying time. I allowed Chris to move into his home in March of this year. Since that time, my dad has run out of funds to pay for an assisted living. I tried taking care of him myself. For 6 months, I moved in with him and was unable to do so. Alzheimer's is too vast of a disease for one person, and I am his sole and only caregiver. 2 older brothers, he has 2 sisters. I'm it. I would like my dad's property to not be affected by anything that my brother may or may not do, and it be allowed to be sold so it can continue to care for my dad in the way that he deserves to be cared for, in an assisted living program that is very expensive, but he thrives greatly. And
May I ask you a couple of questions?
Sure.
Okay. Our officer said that it was a tenant matter. Am I correct? It's an owner-tenant matter?
Mr. Bowles is her brother.
Her brother.
And he is occupying the residence.
Okay.
with no lease, no, it was a verbal. He was in prison. Get yourself together, take a little time, move on. 6 months has passed. The finances have run out. I now need it, and he's not willing to go, and he is causing damage to the property, many violations other than what Ms. Sanderson has said. I've been involved for months. I'm ill myself with several different things and broken my knee and been unable for the last couple months to even be about. It's very emotional, and I apologize.
Sure. No, that's okay. Sure it is. Does anyone have power of attorney?
I do.
You do.
Can you not take legal action to get that brother of yours out of there? or have you tried? Have you?
I'm
It's typically like a
beginning to.
90-day process.
I'm beginning to, like I said, and I've only been up on my feet a few days. And unfortunately, my dad is out of money because of this time frame. And the place is willing to work with me. Like I said, he thrives there. He does very well. He's happier than he's been. I'm sorry.
Yeah. Okay. Board.
We understand, Lisa.
Do you have the property listed for sale?
I do.
Okay.
I've already gotten an offer, and unfortunately, it's a very low offer.
So if it sells, is your brother still going to stay?
No.
He didn't come with the house. That sounds like a good thing. That's right.
No. He also owns a duplex, which that's a whole other issue, and Ms. Anderson and I are, am I saying your name right? Thank you, are involved in that.
Mr. Bowles is here today. He does not have the right to speak, but if the board wants to hear from him or he wishes to speak, he is here.
The brother?
Yes.
He doesn't have. Have you saw his property? And so I don't want to hear him speak.
He has no legal standing.
Or perhaps he would like to just say that he would like to address the violations and help his sister and move on.
He could address the violations by going out mowing the lawn and moving the garbage out of the yard. That's what he could do. I'm more concerned about this lady here and her father. And I know the home is, I'm saying this to the board now, the home is in violation, but we need to have some understanding and compassion as we have in the past and give her the opportunity to get things right. And we need to give her a time frame to do so. And if she comes back, okay, then we can make another decision. But
I'm working.
I make a motion that we table this for 30 days.
I will second that happily.
Actually,
Yes, ma'am.
we were requesting that you find the property in violation against the tenant. We are not trying to put a lien or anything against the property.
But we can't. We can't. Can we find it against the tenant when he doesn't have?
He's the violator.
Yes, I think you can. Am I correct, Madam?
Yes.
Well, if we're gonna.
That's what we did already, right?
Right.
Yes.
We're asking that does not interfere with the sale. We have to have correction of the violation, and we're not getting there. So please find the property in violation, civil penalty for the initial penalty continuing.
But it falls on him. On the
He's
tenant.
the violator, and he's occupying the residence.
And that was the motion that was made and passed.
Unfortunately, if I may, he has no income. He's a convicted felon, is having trouble finding employment, and is just many issues to resolve.
Understood, but if that was the
I
case and
understand.
if the violations were corrected and Chris wanted to appear for the board on request a reduction, we would certainly be happy to entertain that.
I know, and he did not attend at the last meeting where he was called, and he is not good at doing what you are supposed to do his whole life.
So we took a motion, or had a motion here, didn't we vote on it?
Yes.
Yes, we did.
So we found him in violation.
That's right.
We passed.
We
You
passed.
passed the motion.
Okay.
I apologize.
That's my
I was going to be
mistake.
very cool, calm, and collected.
You were pretty good.
Not bad.
Yeah.
I love my dad.
It's harsh, but the only way you're going to get him out of there is do a violation or eviction
I know.
notice.
Yeah.
I mean, it does sound harsh. I've had to do the same things as some tenants, but
It's heartbreaking.
yeah, it is. You're
Yeah, you
captured
are.
in between.
That's right. So
But
we've had the
as-
motion and it's passed.
Yeah.
Right? So
Thank you.
appreciate you coming in and
Thank you
speaking
very
with us.
much.
Thank
You're the one legal authority to run that property.
Yes.
That's right.
I am now. Yeah, that's me. 100% all the way. I will take care of my dad until the day he no longer is here.
Good for you.
Thank
That's
you.
great.
Thank you for explaining the little intricacies of this case. There always are intricacies.
Well, I had it written down, and then I thought, no, I can't read it. I have to say it, and that's probably why I cried.
You did
well.
great. You did.
You did
really
well.
did.
Thank you very much.
Thank
Thank
you very
you.
much. I appreciate.
Yes, ma'am.
And my brother, there's hope. There is hope. So
There's always
Well,
hope.
we wish you all the best.
Yeah.
thank you so much.
You're welcome.
Melody, thank you. You've been wonderful.
Have a good day.
Bye.
Case number 15-CE-5971, Maurizio Lantorno and Christina Eklund.
Case
Case number 041T15CE5971, Maurizio Iantorno and Christine Eklund. This is a home that's roof and fence have fallen into great disrepair. I ended up posting the property. They have been cited with the $50 citation and requesting a board order for that $50 citation, $6202 in enforcement costs and continuing penalties. The home's been without power or occupants for 7 years, but somebody is mowing it and maintaining it, and I've never been able to catch who that somebody is.
I presume it's unoccupied. Am I correct?
Correct.
Yeah, for 7 years.
It's the mowing bandit. No, there are people that live in huts.
My house.
Might be a neighbor. You know, neighbors do that.
That's true. It could be a neighbor.
Yeah, may very well be.
A good Samaritan.
You want to keep their property values up, so you mow the lawn.
Sir, I'll make a motion to that effect. That
Sure.
Find them in violation.
Find them in violation.
And the
Repeat,
cost of enforcement?
And the cost of enforcement. And repeat.
Continuing
violation.
penalties?
Okay.
I'll second that motion.
As defined.
I'll second that motion. All in favor?
Aye.
All opposed? Hearing none, motion carries. Thank you. Let's see, I think that's well, we have some clerk's matters here, guys. Annual report, annual report first. Tammy, pardon me.
That is actually due in December. We just wanted to put the reminder on your board, and Sherry can work with you on that, and we'll bring it back to you in December.
Okay. And we had a discussion about our meeting, our meeting next month falls on a holiday. So because of the scheduling, I think if we can all agree, I think it was maybe best if we just we skip a month and carry everything over.
Into December?
Right.
I will not be here in December. I want you to know that.
You won't be here?
No.
Anybody else that doesn't plan to be here in December?
I have to go north for Christmas and things like that.
I understand. Okay.
Thank you.
Okay, so we're just going to move it to December.
Yeah.
Continue. Don't forget where to come. Don't forget the day to come. Anything else?
Yes.
Yes, ma'am.
I want to introduce Lieutenant Dan Cook, who is the new commander of Code Enforcement.
Oh, good. Hey, nice to meet you.
Very nice to meet everyone.
Oh, thanks for sitting through that whole thing.
Welcome
Officer
aboard.
Cook, thank you.
Very good experience. Thank you.
So
Sure.
Yeah,
he's the boss. He's the boss man for them. Mm-hmm. Very nice to meet you, Officer Cook.
That's why you guys were behaving.
All right, hey guys, thanks for coming. Meeting's adjourned.